Hi, I'm Shauna Correa. I'm a shareholder in the San Francisco office of Weintraub Tobin.
I'm Anders Bostrom. I'm an associate attorney in the Sacramento office of Weintraub Tobin. So, Shauna, I hear you've been representing your clients in lawsuits related to website accessibility. Can you tell us a little bit about that?
Yeah, Anders, it's really interesting. We are getting just a slew of demand letters from plaintiffs' lawyers representing individuals who have visual impairments or other disabilities, claiming that our clients' websites are not accessible enough. And it's interesting because website accessibility issues are really an outgrowth of the ADA, Title III specifically. And so what Title III does is it mandates that places of public accommodations and commercial facilities are essentially equally accessible to people with disabilities, and that they are not excluded or given less access or lesser access.
People might think that because Title III was enacted in 1990, that it doesn't apply to websites. Well, that's not the case. Recent case law, such as Robles v. Domino's that came out in 2019 suggests that when a brick and mortar or physical location has a website that facilitates and connects the physical location's goods and services to the consumer, that the website can actually be covered and needs to be accessible as defined by the ADA. So, Shauna, can you explain a little bit about how this statute that's designed to cover physical locations actually applies to websites?
Well, in a nutshell, there's some language in the ADA itself that's not per se limited to physical spaces. For example, the ADA requires businesses to furnish auxiliary aids to ensure effective communication with people with disabilities. Now, that doesn't necessarily limit to a physical space. And for another example is that the ADA requires businesses to take steps to ensure that individuals are not denied service or treated differently because of their disabilities. And so you can see that if a website is not set up to be able to be perceived or heard or viewed by a person with an impairment, like a visual impairment, a hearing impairment, or fine motor issues, that the ADA puts the burden on the business to make sure that they take steps to make that website more accessible. And also in California, there's another law, Civil Code Section 51, which is known as the Unruh Act. And that takes out really any question, at least in California, that websites need to be accessible for California residents with disabilities, even if it's purely a virtual website that is not tied to a physical location. So, to sum it up, if a website is not accessible to someone with a visual, auditory, fine motor, or other impairment, a business could be liable for an ADA or Unruh Act violation. And as you know, Anders, about 26% of Americans actually have some form of a disability. Anders, can you talk a little bit about what the standard is to make sure that a website is compliant?
Of course. So the standard right now, it's a little bit vague because there's nothing that's been codified, as we've explained. However, there is what is known as the WCAG, which is the Website Content Accessibility Guidelines. And there's an acronym that they use to highlight the different areas of accessibility. And this acronym is POUR, P-O-U-R, which stands for perceivable, operable, understandable, and robust. Now, the WCAG has updated these guidelines a few times since it was created in 1999. This includes 2008, and then the 2008 standard was updated in 2018, but none of these standards have been codified into law, as was mentioned. We've gotten the courts who have referred to these standards as a way of explaining how accessibility can be accomplished, but liability based on a failure to adhere to these standards hasn't occurred yet.
I'm sure our viewers are wondering if their websites are compliant right now. Is there anything that you would suggest that they do at this point with relation to the WCAG or any tools available?
There are actually a good number of tools that businesses can use to evaluate where they are in terms of accessibility on their website, as well as what they can do to improve. Some of these tools include Google Lighthouse, that does a good job at doing a very surface level overview as to what the glaring errors are. This can be contrast, this can be links as to whether or not there's alt text included within those links, metadata that helps describe the pictures that appear on the website, or even video and audio descriptions of actual videos that appear on the websites as well. It's also important to work with a web designer in order to make sure that your website is accessible. Because as much as these different tools can be used to evaluate the accessibility of a website, what we have found is the industry has tried to tote that overlays or plugins can be used to make your site accessible. And they seem really convincing and really cheap based on what it would take to hire a web developer. But we've seen, in cases have come out, and settlements have been made that show that these overlays and these kind of third-party options just really don't cut it in the terms of accessibility. And so it's really important to talk with a web developer and understand what you can do to make your website accessible to avoid any sort of liability.
I think that's great advice. And I always think training is important. So, and that goes for web designers as well, that the web designers that our businesses may hire, a key component of their training should be disability access for these designs that they're doing. So that's really important. And, like everything else, some of these catchy widgets and overlays are tempting because they're much less expensive than a full audit and monitoring and diagnostic software. But all business owners are going to just have to balance that, cost of compliance versus the risk of exposure to liability. So, and like I said earlier, I've seen a lot of demand letters targeting even small and more obscure businesses, not just the Domino's pizzas of the world. So, one thing I do want to make sure that people take away from this before you go off and look at your website is, if you do receive a letter from a plaintiff's attorney asserting violations of the ADA and the Unruh Act, and demanding some kind of settlement, the settlement might be a small amount, it might be a large amount, but it's important to consult with legal counsel right away. Don't admit, of course, fault or liability, but your legal counsel can help negotiate a good result. And, as a positive spin on these, website accessibility claims, truly everybody does benefit if the business's website is compliant and accessible, because we want all of your possible customers to be able to enjoy the full range of products and services that the business offers. So, I think it's important to be mindful of the risk, but also have a positive outlook that this is rewarding for all parties to have your website be as accessible as it can reasonably be.
Thank you, Shauna, for ending on such a positive note. That's about all the time that we have for today. But if you have any questions, feel free to reach out and give us a call. We'd be happy to help. Just as a quick sign-off note, please do subscribe to Weintraub Tobin's blogs, including the LNE blog, for more updates and information about this rapidly evolving topic. Thank you very much.